Good morning. I'm Brad Usher, Senator Krueger's Chief of Staff. The Senator's sorry she's not able to join us today, so I will be moderating to this morning's event. I want to welcome all of you who have joined us today on Zoom, on Facebook, and by phone. Before I get into today's proceedings, I wanted you to be aware that we do have closed captioning. As a viewer, you have to activate closed captioning to view the text on your device. If you're in Zoom, click on Live Transcript in the meeting controls to start viewing closed captioning. If you're in the Facebook Live event, you will see a settings button on the bottom right-hand corner of the video. Click Closed Captioning CC to start. Before we move to the roundtable discussion, I just have a few COVID-related updates. If you are having difficulty getting a second dose appointment at a pharmacy or other vaccine site, you can go to a city-run vaccine site to get your second dose, but you must bring your COVID-19 vaccine card. You can call 877-829-4692 to locate the city-run vaccine site that is closest to you and that offers the same vaccine dose as you received for your first dose. Again, that number is 877-829-4692. You can also call that number for a list of walk-up vaccine sites, which is updated weekly and subject to change. Starting today, you can also go to any state-run mass vaccine site, such as Javits Center, to get vaccinated without an appointment. It's getting really easy to get vaccinated at this point, and if you haven't done so, this is your opportunity. The city's starting to reopen. The mayor announced that we're going to reopen more fully in July, and it's really important that everybody get vaccinated before then. To access the state-run site, you can call 833, or to find out locations about state-run sites, you can call 833-697-4829. That's 833-697-4829. If you have expressed interest in receiving an at-home vaccination and you have not received a call from the city, they are still in the process of calling interested New Yorkers to determine if they are eligible for the program. Now let's turn to today's proceedings. This event is being recorded. We will send you a link of the video's programs to everyone who RSVP'd. We will also post today's PowerPoint presentation, so don't feel like you have to get every detail down if you're taking notes. You can review it later. Today, we are offering the 5th senior roundtable in our series, Being Mortal, thinking about end-of-life decision-making. Some of you may recall that in February, we had a senior roundtable dedicated to advanced planning, which focused on healthcare proxies and living wills. We will post the link to that event video for those who missed that roundtable presentation. At that event, many people expressed an interest in learning more about advanced planning as relates to medical needs, guardianship, wills, trusts, and power of attorney. So we decided to add an additional event, and this is that event, to look at those advanced planning issues. We are lucky to have two wonderful speakers, Wendy Handler, Director of Onsite and Special Programs at DOROT, and Tina Janssen-Spinosa, Staff Attorney and Total Life Choices Program Coordinator at the New York Legal Assistance Group, who are joining us today. After the presentation, I will moderate the Q&A portion of the town hall. Now it is my pleasure to turn the proceedings over to Wendy Handler and Tina Janssen-Spinosa.
Good morning, everybody. Tina.
And you need to unmute, Tina.
Sorry, it seems like I have a double unmute, one on my phone and one on the screen. So now I'm unmuted?
Yes.
Excellent, thank you so much. Let me share my screen now. And we can get started. Excellent, can everybody see the screen? Yep, PowerPoint? Yes, excellent. Thank you so much. So now here we go. Wendy, it looks like I need to double tap. We changed the way I usually see my PowerPoint. So Wendy, please go ahead. Sorry about that.
Okay, good morning, everybody. As Brad said, my name is Wendy Handler, and I'm the Director of Onsite and Special Programs at DOROT, and it's so good to be with you this morning. I want to just say a little bit about DOROT before we begin our presentation this morning. DOROT has been an innovative leader in programs that enhance the lives of older adults for more than 40 years. We have a range of vital supportive services and opportunities that encourage participants to build social connection with peers and those of other generations through volunteer relationships of all between older adults and volunteers of all ages. While our headquarters in Manhattan's Upper West Side is temporarily closed for now due to COVID restrictions, our on-site at home programs bring the same vibrant, interactive, and life-enhancing programs that people can enjoy on site right to your home via Zoom video conferencing or telephone. As the slide says, we offer a range of programs and services at DOROT, which you should know about. We have a friendly visiting program, which I mentioned. We have a door-to-door travel program that supports independence by providing shop and escort services for older adults from their homes. Our social workers provide a range of supportive and vital services, and our Connect Through Tech online class program connects older adults throughout the country to sharpen their digital skills. So Zoom, phone, and iPad. And the reason for us being here today, we also support older adults around preparing their advanced healthcare directives, which I'll say more about in a few minutes. Tina?
Thank you. And my name is Tina Janssen-Spinosa. I'm an attorney with New York Legal Assistance Group, where I coordinate Total Life Choices. New York Legal Assistance Group, we are a not-for-profit that provides free legal services to low-income, low-asset New Yorkers, as well as financial counseling, and we also engage in policy advocacy efforts. The program that I coordinate, which is Total Life Choices, seeks to empower people so that they can make decisions and document their wishes regarding what they would want or not want should they become incapacitated or should they die. The information that we're going to be providing today is entirely focused on New York law. Also, so whatever I say is most likely not going to be applicable in California or in any other state, New Jersey, Connecticut. The other important message that I'd like to give is that we will not be providing specific advice. We are not providing legal advice. What we're doing is providing general information so that you are more informed and that you can seek out the services of an attorney or of a professional that will be able to assist you. Wendy?
So one thing we know for sure is that everyone needs to make a just-in-case plan, even and especially when we're feeling good and have the capacity to think through different scenarios. At DOROT, we talk with many community members who hesitate to think about these decisions, even while recognizing how important they are, not wanting to hasten the arrival of difficult situations by speaking them out loud. While we understand the hesitancy, it's human nature, we know that when we help each other think through the answers to the questions you see here on this slide, it helps create peace of mind. We've seen how people are able to move forward knowing they've taken care of business by planning ahead. As you'll learn from Tina throughout this morning's conversation, it's important to speak with an attorney to discuss life planning documents such as wills, trusts, powers of attorney, and long-term care planning. At DOROT, one of the important ways we support our community, including everyone here with us this morning, even if we haven't met yet, is by offering conversations and assistance in completing advanced healthcare directives, healthcare proxies, and living wills for free, no charge. And I'll say more about that later. My last word here is to give you all a thumbs up for being here this morning, which is a first step towards answering these important questions for yourselves and those in your care circle as a first step towards setting your mind at greater ease.
Okay, so I'm going to be going a little bit over the goals for this session. We have a lot of material to cover. If you haven't really looked into your planning opportunities or possibilities, it's going to be a lot. And that's okay. I would just suggest that you kind of like go with the flow, listen in, hang in there. You're going to have the opportunity to listen to this again and review the slides, but I do realize that's going to be a lot of information. I will be speaking pretty quickly. If I do, please, and if I speak too quickly or if I lower my voice at some point, please put it into the chat. And somebody from Liz Krueger's office will intervene and kind of like say, Tina, you need to slow down a little bit. So there are different types of planning that you can do. You can plan for your physical body. And that's where Medical Advance Directives come in. Other medical considerations need to also be at the forefront of our minds, namely assistance for activities of daily living when we're no longer able to transition from our beds to our sofas or bathe, and whether we want to remain in the community or go into a nursing home. We also need to consider funeral arrangements, and we will be discussing appointments of agent to control disposition of remains. Now, you also will need to consider planning for your finances. So that includes powers of attorney, how you own your property, trusts, last wills, and testaments. The Senator Krueger's office will be providing you with a few documents. One of them is a one-sheet document, and I know that each time that I say appointment of agent to control disposition of remains, people start writing furiously and get a little bit upset because I know it's a long sentence and there are a lot of different words. This sentence and all the names of these documents, powers of attorney, all of these documents are in that one pager with a very quick summary of what they do. So you will have that. The other way of looking at this, instead of looking at our body and our finances, is to think about the different planning tools that can be used either during our lifetime, that might be used during our lifetime and might be of use after death, and then used after death. And that's why I have this little chart here that shows you what can be used and what is useful during life and what comes after death. I'm not going to linger on this in light of the very little time that we have. So all advanced planning documents require capacity. If you're listening to this and you're able to follow what I'm saying, chances are you have capacity to do the whole gamut of planning documents. If you logged into Zoom today, and if you are thinking about what we're saying, if you're following what we're saying, chances are you're going to be able to do every single document that you need to do to set up a plan should something happen. Each document requires a different type of level of capacity. The highest level of capacity at this point in time that's needed for a document is for a power of attorney. And what I also want to mention, because I get a lot of phone calls from people who say, you know, mom was diagnosed with dementia, so she no longer has capacity. Attorneys do not use the same criteria as doctors in order to assess capacity. So the best idea, if you think that if you were diagnosed or if somebody else was diagnosed, the best thing that you can do is actually consult with an attorney and speak with an attorney, and the attorney will make the determination as to whether the person that they're consulting with has capacity or not, and to what extent and for what type of document. So advanced planning documents that will take effect during your lifetime are Medical Advance Directives and powers of attorney that require, both documents require a surrogate, a proxy, someone else. That's why I have this little blue person there. They require someone to be able to step into your shoes to make decisions for you on your behalf. Wendy?
So everyone needs to plan for a time when we're unable to make our decisions about our own health care, just in case, right? Just in case we're not able to speak for ourselves at any time for any reason. A key part of that is understanding the choices that we have. As you'll see at the top of this slide, there is a previously recorded presentation that Brad referred to, made by Tina, that reviews all the details of Medical Advance Directives, and that will be available to you following this morning's presentation. Medical Advance Directives include healthcare proxies, which allow you to appoint an individual to speak on your behalf in case you're unable to articulate your wishes around healthcare decisions for any reason yourself. Living wills, which provide space for you to more fully outline your healthcare wishes. Do not resuscitate order or DNR, which has to be completed by your physician. And MOLST, the medical order for life-sustaining treatment, which is a document also completed by a doctor or medical professional. The default listed in red here is what happens if you have a medical emergency and have not completed advanced healthcare directives. Members of your family in an order designated by the state are asked to speak on your behalf, and they might not actually be the people in your life that you would like to have that job. So it's very important to consider who you might wish to appoint. It's, as I mentioned before, DOROT assists individuals with conversations around healthcare, advanced healthcare decisions free of charge. Brad will, or somebody will provide a link at the end of this conversation, and please reach out to us if you're interested. We're part of an initiative here in New York City called What Matters, Caring Conversations Around End of Life, which is based on the Respecting Choices model of advanced healthcare decision-making. Again, DOROT offers this free of charge. Please be in touch if we can help you in discussing and or completing your advanced medical directives. Tina?
Okay, and wonderful. It appears that my neighbors have decided to do some construction today. And I'm hoping that you're going to be able to hear my voice above this. That Wendy, is this okay? Okay. I'm going to try to speak louder than what they're actually doing, and I have no idea what they're doing or when they're going to stop, and I apologize for that. The power of attorney, as you can see, I've got my little blue person there, requires an agent. What is a power of attorney? A power of attorney is a document that allows you to designate someone that you trust to manage your financial, your banking matters, your Medicaid planning during your lifetime. A power of attorney dies with you. When you do a power of attorney, you do not give up your powers, your rights. You are actually authorizing someone else to act on your behalf for the powers that you have decided to give them. So you can give very extensive powers, or you can give them very limited powers. For example, I authorize you to handle my banking transactions. I authorize you to sell this and this property. I authorize you to renew my lease. Or for planning purposes, what you do is you give a maximum amount of powers, but those powers should be limited by the amount of trust that you have in that person. Don't go and do a power of attorney designating someone as your agent to handle your banking transactions when you would not feel comfortable giving them 10 blank checks. If you feel comfortable giving someone 10 blank checks and knowing that they're going to be using these checks in light of what you told them or for your best interests, then yes, you would probably feel comfortable giving them power of attorney to handle your banking transactions. If not, you need to reconsider either your agent or the powers that you're giving them. A power of attorney is a durable power of attorney. It means that once it has been executed, it comes to life. It's in effect. There used to be, a lot of attorneys used to do springing powers of attorney, which means that they would spring to life when you would become incapacitated. You lost capacity, you couldn't do things anymore for yourself, or certain things that were listed in the power of attorney, and that's when the power of attorney would come into effect. That's no longer the case. Powers of attorney, there are very few attorneys that do that. I don't have the time to go into why it's not such a good idea to do a springing power of attorney, but the power of attorney comes into effect once it is executed. Your agent must be over the age of 18. The main idea behind the power of attorney is how much do you trust your agent? You can choose anybody over the age of 18, but the question is how much do you trust them? The power of attorney cannot be used after your death. So if you're the principal, if you do a power of attorney and you designate Wendy, after your death, Wendy can no longer act with your power of attorney. She is no longer empowered to do anything that you have authorized her to do with your power of attorney. And that's very important. I have a lot of people that tell me, they had a family member who died and they're trying to handle their estate via power of attorney. And of course, that's a big no-no. If there is no power of attorney, then the default, depending on what the situation is and what the need is, there might be certain remedies, namely if it's to obtain Social Security benefits. There might be other ways of going about matters to help the person who is now incapacitated, or guardianship. And we'll talk a little bit more about guardianship in a little bit. Wendy, I believe, sorry about that. Okay, so guardianship, perfect. So a guardianship, which is an Article 81, if you want to start looking that up a little bit on Google, as opposed, because there are other types of guardianships. The guardianship that we're talking about is an Article 81 guardianship in New York. What that means is that somebody in the community is concerned about you, and for whatever reason, because you're wandering at 2 o'clock in the morning, because maybe you're spending money in a way that is different from your typical pattern, or there might be other concerns. Medical decision making when you are in the community and you didn't do a healthcare proxy, for example. Somebody who's concerned, whether it's a physical person or an agency, for example, Adult Protective Services, is going to file to obtain a guardianship over you. And what that means is that a court is going to review their petition, what they're asking, see whether it makes sense. There is going to be someone from the court who's going to go out and speak to you and speak to your family members, potentially your neighbors, other people that might be involved in taking care of you or assisting you. And that person is going to be the ears and the eyes of the court and is going to report back to the court to let them know what their findings are, because some people are trying to obtain guardianship over persons and maybe the guardianship isn't warranted. So the court does send somebody out to speak with you, with people who are around you. And then the court will make a decision as to whether a guardianship is warranted or not, and what powers should be given to the guardian. And those powers will be the least restrictive possible. They are tailored to the person who needs a guardian, to their needs. It's not just a big bag of, oh, you get to take care of everything for the person who needs a guardian. No, it's you need to take care of their banking transactions, for example, if things have changed in light of typical spending habits, for example. Guardianship proceedings are invasive because somebody is going to come and investigate and ask questions. They can be costly because often an attorney is hired because although you can, family members can petition pro se, it needs to be navigated. And they're also time consuming. Guardians will have to go through, once a guardian is appointed, they have to go through a training, they have to provide annual accountings. So the reason why I really went into this guardianship is because really by doing a power of attorney and by doing a healthcare proxy, you are planning in ahead of time so that guardianship will not be needed. If you appoint, if you designate the appropriate trustworthy people and set these things up in advance, chances are you're not going to need a guardianship. The flip side of that is if you have no one to appoint. I also have a lot of questions from people who say, well, what if I have no one? Who's going to take care of me? Well, if you have no one, there are eyes and ears in your neighborhood, in your surroundings, and then Adult Protective Services will be called in. And there are community guardians, there are guardians that are not family members, that have no relationship to you, that can be appointed to make sure that you are being taken care of. Wendy, you wanted to say a word about Medicaid?
Sure. The slide that Tina has shared has a lot of detailed information, and I'm not going to really speak to that. That's not our area of expertise. That's really NYLAG's. But I wanted to say a word about Medicaid based on DOROT's years of working with our community. First and foremost, Medicaid is an option to assist everyone in successful aging, and we encourage everyone to consider it. I want to clearly state that there is absolutely no shame in becoming a Medicaid beneficiary, none. We've seen far too many situations where people have resisted and it has not worked out well. Medicaid provides more comprehensive benefits than private insurance at significantly lower out-of-pocket costs to beneficiaries. And with proper planning, like with the attorneys at NYLAG, Medicaid is a valuable tool that allows us all to wield the same spending power that we would have privately. We encourage everyone at DOROT to examine this option and work with an attorney to planfully and legally transfer assets to become Medicaid recipients. It's an option, again, to assist in successful aging, and we really encourage people to consider it.
Okay, and I just checked the time, and apparently I need to speak even faster. So Medicaid has income and asset limitations. So, and there's a way to plan for Medicaid, namely in terms of income. You can set up a pooled trust. Assets, you may do planning via irrevocable trust, not revocable trust. That's not going to help you for your Medicaid planning. Last minute Medicaid planning is also a possibility, and that's why it's always a good idea, again, to have a power of attorney, because if you have a power of attorney designating an agent that will be able to handle whatever transactions need to be done in terms of Medicaid planning, you have set up a default plan just in case. Medicaid is the only provider of long-term care assistance for activities of daily living. Activities of daily living, that's eating, bathing, getting dressed, toileting, mobility, and continence. So long-term care for assistance for activities of daily living, that is not the same as what Medicare will help you with. Medicare will help you with, and yes, they might pay for a home health attendant for a few hours while you get better. Medicare helps you with rehabilitative services. So if I fracture my hip and I need help for a little bit, Medicare will help me. Medicaid will help for activities that typically a family member might do. They might help you with your shopping, with cleaning up your apartment, with transferring, with bathing. That's something that Medicare will not help with for long-term care. So long-term care can be provided in the community, in other words, in your home or in an institution, nursing home. Nursing homes in New York cost well over $100,000 a year. So it's very expensive to be able to receive the care that many of us need as we age. So what I'd like to do now is talk very quickly about trusts. So what is a trust? A trust is an entity, or it's actually a document. A trust is a document that you sign, that you set up. The idea behind a trust, most importantly, I have a lot of people tell me, yeah, I signed a trust, and I ask them for what, and they don't know. All trusts are going to serve a purpose. And if you go about the idea of wanting to set up a trust, the question is, what is the purpose? Why are you setting this trust up? Is it to benefit yourself? Is it to benefit somebody else? Is it for tax purposes? Is it to avoid probate? We'll discuss probate in a little bit. Is it for Medicaid purposes? And again, for Medicaid purposes, you need to set up an irrevocable trust, not revocable. Revocable will not help. Trusts can be created for the beneficiaries during the lifetime of the person who's setting up the trust. They can be set up after somebody's death by a will. And there are many types of trusts. So a supplemental needs trust, that is to assist somebody who's receiving government benefits, somebody who might be disabled. There are age-terminating trusts. In other words, the beneficiary is going to obtain income assets of the trust at, let's say, 1/3 at the age of 25, another third at the age of 35, et cetera, et cetera. So it kind of like terminates at certain ages. Of course, there are Medicaid trusts. There are pooled trusts also that serve for Medicaid purposes, and that's just for income only. The pooled trusts are managed by not-for-profits that are the trustees, and what happens is part of your monthly income goes into that pooled trust. You have a sub-account, and from that sub-account, certain recurring bills of yours, only yours, get paid. So maybe your rent, maybe your electricity, your cell phone bill, et cetera, et cetera. And that allows basically for you to qualify for Medicaid because your income, the part of the income that goes into the pool trust does not get counted by Medicaid. So it allows you to qualify for Medicaid and yet still be able to spend pretty much the same amount of money. So you need an attorney to set up a trust, please. I know that there are forms online. I have seen people who tried to set up trusts, and they definitely signed a document, but it's not a trust. So please be very cautious. If you're trying to set up a plan, get the proper advice. Property ownership. So property ownership is also one of those things, just like with trusts, where the way you own your property is going to have an effect during your lifetime and also after your death. So you might have property that you own by yourself, property that you own jointly with someone else with right of survivorship. That means if one of you dies, the other one, the ownership is automatically going to transfer to this other person. That means that if you own something, if you own a house jointly with right of survivorship, and you also do a will, and in my will I say I leave my house to Wendy, but I own my house jointly with Brad. At my death, Wendy is not going to get my house. Brad is going to get my house because this property was already spoken for and will not go through my estate. So what I would suggest is that everybody take a look at what they own and how they own it. Because if you also put a designation, payable on death, transferable on death, or designated beneficiary, these assets are not going through your estate. Each type of ownership is going to have repercussions during your lifetime as well as after your death, and you should be well aware of these repercussions. I want to talk quickly about another document that can be done. And as you see now, we're transitioning into what happens to us after our deaths. That's the appointment of agent to control disposition of remains. You can designate someone to handle your remains after your death. There's a link here that will lead you to the New York form. New York law, if you do not do an appointment, will provide an order within which people can make these decisions if you fail to make them during your lifetime, and whoever is designated by statute is going to have control over what happens to your remains if you do not do an appointment of agent to control disposition of remains. I want to talk really quickly about pre-planning and prepaying your funeral. If what happens to your remains is your body is important to you, I would highly recommend that you prepay or that you pre-plan your funerals, meet with various funeral homes, talk with them about the options, talk to your family. If you are low income, low asset, you need to think about who's going to pay for your wishes and how that's going to be done. And there are difficult conversations that need to be had and thoughts that need to percolate through our brains when we do not have the means to get what it is that we would want. Death certificates. Death certificates are very, very important for several reasons. They are needed to probate a last will and testament. They're needed to handle an estate if there's no last will and testament. They are needed to obtain funds that are payable on death. So if you have an account that says payable on death to Justin, Justin is going to need an original death certificate in order to obtain those funds after your death. The first person who's going to get a death certificate is the person who is in charge of your funeral. So if you do an appointment of agent to control disposition of remains, or if the default is that Wendy is going to get the death certificate, well, hopefully Justin and Wendy get along really, really well, because if Wendy does not want to release those death certificates, Justin is going to have to go through a proceeding so that he can obtain one of these death certificates. And this is all a hassle. So when you set up a plan, you need to think about the different pieces of your puzzle to make sure that everything flows as easily as possible. So a last will and testament. A last will and testament is going to control everything, the stuff, everything that does not bypass your estate. and I'll give you a list of things that do bypass your estate, and that's namely payable on death or owning things with joint of survivorship. That does not go through your estate. So your last will and testament, it's a document. It allows for you to state who's going to get what after your death. It allows for you to choose an executor, somebody who's going to be in charge of gathering your belongings, distributing your belongings, paying off creditors. It allows for you to potentially appoint a guardian to look after minor children. You can make gifts to whomever you want through your last will and testament, but your spouses have rights. And if you do a last will and testament, it would be $50,000 or 1/3, whichever is higher, of your net estate. And you should hire an attorney to do a last will and testament. There are requirements in terms of how we draft them and execution requirements. What happens during the execution ceremony while you sign, what you say to your witnesses, the conversations that you have so that they may attest to your capacity should they be hauled into court if your will is contested. These are all very, very important factors that need to be taken into consideration. Intestacy, that's the default. Just like with everything else, if you don't set up a plan, there is a default rule in New York. So if you do not do a last will and testament, or if your last will and testament is just a piece of paper and is not valid, then there are rules in New York that basically state who is going to get what. Your spouse is actually going to wind up more, which is $50,000 plus 1/2 of your net estate. And if you have a spouse plus children, then it would go to your spouse and then the rest to your children. So the $50,000 plus 1/2 to your spouse and the rest to your children. If you don't have any children, then it would go all to the spouse. If you don't have any, if you do not have a spouse and you just have children, it all goes to the children. If you don't have a spouse and if you don't have children and just have grandchildren, it basically trickles down. If it cannot go down, then it's going to go back up. So in other words, if you don't have a spouse or any descendants, then whatever you have, your belongings are going to go to your parents. If your parents have predeceased you, then it's going to go to your siblings. And that includes your siblings that were legally adopted and your half-blood siblings. So, and I get a lot of people that are often upset because they don't want to share it with their half-siblings. But so the assets that bypass your estate, so that do not wind up in your estate, are life insurance with a designated beneficiary that has survived you, of course, pension retirement plans with designated beneficiary, even though sometimes a spouse might have rights to certain pension and retirement plans. So if I designate Wendy on a retirement plan, my spouse might be able to actually say, no, Wendy's not entitled to all of this. I actually get a share. And basically will re-include that into the estate. Other assets that bypass your estate are whatever is payable on death, transfer on death, taught in trust bank accounts, joint accounts with right of survivorship, but not convenience accounts. Convenience accounts are accounts that allow for somebody else to pay your bills, for example. And property held jointly with right of survivorship. Now let's talk about surrogate's court. Surrogate's court, a last will and testament is a document. It's a piece of paper, but it only is armed with teeth once after you die and after it is shown to the court, to the surrogate's court, and demonstrated to the court that it is a valid last will and testament. Before you die, a last will and testament is a piece of paper. You can rip it up. You can change your mind. Your original last will and testament needs to be found after your death in order to be probated, with some exceptions, but the last will, let's just say at this point in time, the last will and testament the original needs to be found. Also, if you die without a last will and testament, there's going to be a procedure in surrogate's court unless everything that you owned, all your stuff, actually bypassed your estate and went directly to certain people. But there's always something that's going to be left over that didn't automatically go. Certain family members will need to be put on notice. Even if you really hate your family members, the law says that if there's an administration or a probate proceeding, they will need to be put on notice. It's a good idea, even if you really, really hate your family members, to leave a list of who those family members are, because it will make things a lot easier for those who are in charge of your estate. There are also when there are minimal assets, there's also a small estate affidavit, and that does not require court involvement. And in New York, we have a wonderful entity that's called the public administrator. So if nobody steps forward and if nobody handles the estate, the public administrator will. Safe deposit boxes. Please, if you own a safe deposit box with somebody else and you think that after your death that somebody else is just going to be able to go into that safe deposit box and obtain whatever is in there, think again. That's not what happens. The safe deposit box gets sealed and a court order will be required to open the safe deposit box, and whatever is inside the safe deposit box will need to be inventoried and is part of your estate unless the co-lessee on the box actually is able to demonstrate that what's in the box is partially theirs. You can imagine if it's the other way around. So let's say you have a joint safe deposit box with your daughter thinking, I'm going to die first, so my daughter's going to get my belongings. Well, unfortunately, and God forbid, your daughter predeceases you. Well, now whatever is in that safe deposit box is part of your daughter's estate, and you're going to have to demonstrate that what is in there, if anything is yours, that it actually is yours and not part of her estate. We currently are able to, thanks to executive orders that have been renewed, we are able to remotely notarize and witness. So there is no need to, in light of social distancing, to actually meet face-to-face. We have set up procedures to do that, but we are telling all of our clients that once, hopefully, once things will be safer, and once our offices reopen, that they will need to come back into the office so that the documents can be re-executed so that they have original documents all with wet signatures, as opposed to what we're doing right now, which is electronic transmission. It is very important for you to leave breadcrumbs. Once we no longer can communicate, people around us are looking for information. Who is your cell phone carrier? Who's your insurer? Who needs to be contacted? Whether we become incapacitated or after our death, this information needs to be found. Please leave breadcrumbs. I would suggest you I call it a shoe planning box. You can call it whatever you want to call it, but put it in a safe place. Let your loved ones know where important information is. If you live by yourself, or if you don't have close family members or friends, on the inside of your front door, decorate a paper bag. Write on the paper bag important information in case of an emergency. Put the list of your medications. Put your healthcare proxy in there. Put people that need to be contacted in there so that that information is readily available. Even if EMS comes to your home, that information should be available. I wouldn't put my social security number in there, but definitely contact information if somebody is overseas or in another state. very quickly, there are a lot of unclaimed funds and unclaimed life insurance policies. I have provided the links here, missingmoney.com. Of course, there's a New York State Controller's Office that you can log on to. That's a state-specific, where you can type in your name or anybody else's name and see if they're holding any money. Missingmoney.com actually has other links to other possibilities. And of course, I'm not finding what U.S. Treasury bills, for example, that have not been claimed. These things can be searched if you go to missingmoney.com, and also life insurance policies that have not been paid out. There are hundreds of thousands of dollars worth of unclaimed funds that you can look into for yourself or for other people. It's not too late to plan. As long as you're able to do so, you should complete your planning journey. You should be consulting with an attorney. Every now and then, when there is either, if you think about it, whether it's on a yearly basis, I don't know, when you daylight savings, time change, take a look at your documents. Are they still up to date? Any great big event in your life, somebody gets married, somebody dies, somebody is born. Are there any changes that you need to make to your documents? Have you changed your mind about anything? If appropriate, have a conversation with your family members and your friends. And taken out of context, but I did give a little quote, which I think is very true. It's very empowering to think about what would happen should you not be able to communicate. It clarifies things. I have a lot of people, when they hear about the default rules, they're just kind of like, I don't want that. Well, what is it that you do want? And it allows them to think about their relationships, what is important to them. The silver lining of all this is it will clarify your life once you start thinking about these things a little bit more. Wendy, did you have anything to add after my mad race here?
I didn't. I think you were very thorough.
Okay, thank you. Great. I see Brad back up on screen. Hi, Brad.
Hi, thank you both, Wendy and Tina. That was really great. A lot of information. And again, if you didn't get it all the first time, you can watch the videos again. And also there'll be a copy of the PowerPoint is available, and as well as links to the documents that we've discussed here. Lots of good questions, some more technical than others, but I'll just jump right in with a...
Justin, Wendy wanted to go over quickly one of the questions that we had received, right? Wendy, was there, I believe?
Well, I don't know what Brad's going to serve up, but if there's a question about living wills, I'm happy to address.
Oh, okay. Well, yeah, so I'll start with that one since we got that one. There's how effective is a living will? It was one question that came up.
How effective is it? Well, it's effective on a case-by-case basis, but just wanted to share a little bit about living wills, because it can either be a formal document or something more free form, like a letter or an audio or video recording. It's meant to be instructional in nature and offer guidance, not mandates. So whatever you choose, you have to be very mindful about initialing each page and signing each page in writing. And make sure if you create a recording, that you state your name and the date clearly so that it is more likely to be honored. It's not technically a legal form or format like the New York State healthcare proxy. A living will is an effective way for your voice to be heard if you can't speak for yourself, and is often used if you have no one to appoint as your healthcare proxy. There's a lot of evidence to indicate, especially in this past COVID year, that a living will be respected and honored. It can also serve as a conversation starter if you decide to ultimately designate a healthcare proxy, because you will have it's like a roadmap of guidance. So there's lots of templates for living wills that can guide you in providing information to help your healthcare team or your decision maker know what you want. And again, DOROT's able to assist you in choosing the right living will for you and helping you to complete it.
And I'll go with one more question that came in through the chat. A reminder, you can, if you're in Zoom, you can enter questions in the Q&A, or you can enter questions in the chat in Facebook. Somebody asked, what can you do if a doctor or hospital ignores your healthcare proxy or the wishes of your family?
I'm hoping, I'm putting myself on mute because of the noise, and I hope that that makes a difference. Can you hear the background noise of what's?
Yeah, it's not too bad though.
Okay, thank you. Has anybody ever encountered that situation in New York where a doctor is refusing to honor a healthcare proxy, or is this a hypothetical question? Because I mean, unless the healthcare proxy was, unless they're questioning the competency at the time that the principal executed the healthcare proxy, or the signatures, or if it wasn't validly completed, in other words, it's basically not a healthcare proxy. I've never really heard of a hospital refusing to honor a healthcare proxy that was properly executed.
Okay, so
I feel this is more of a hypothetical question.
And if it's not hypothetical, I would assume that there would be a complaint process against the doctor that you could initiate through the Office of Physician Discipline, because that would be a violation of their
right.
duties. But
patient advocate in the hospital. I mean, something not quite right.
Yeah. Okay. So moving on to some questions more related to today. I don't know if you can answer this, but is there an average cost to set up a revocable trust in NYC, or general a sense of what things cost if you're working with an attorney on these things?
No. What I would suggest is that they call up attorneys and see what their cost is. I kind of like the idea of not paying an hourly rate. I like the idea of paying a flat fee, because then I know what it's going to cost me in the end. You know, hourly rates, they can add up pretty quickly. I'm a little bit I'm a little bit surprised that they actually ask for a revocable trust, because I mean the purpose of the revocable trust would be potentially to avoid probate. And does it make sense in their situation? Again, a trust serves a purpose. What would be your purpose for the trust? Does it make sense for you to do a revocable trust as opposed to doing a last will and testament, which typically costs less? I mean, there might be other planning pieces, and I'm not saying that's not a good idea. What I'm saying is think about why you're doing what is the purpose. It's my understanding that for an irrevocable trust, which is also which is Medicaid planning, right? So you do your power of attorney, you do your Medical Advance Directive, your irrevocable trust, your last will and testament. It's my understanding that's anywhere between $8,000 and $10,000.
Okay, got it. Okay, a couple of questions about power of attorney. Can you designate sequential powers of attorney? If X is no longer alive, I appoint Y. And also, can you appoint two daughters to be your power of attorney? I'm guessing there's problems with appointing two people together, but you can tell me.
Yeah. So yes to all of the above. You can appoint a first agent, and if that first agent is no longer available, then your successor agent could step in. You can also designate two or more agents to act simultaneously, so they're at the same ranking, right? So I can say Wendy, Brad, and Justin are all my agents, and you can all act simultaneously. And I can say, but you know what? I trust all of you, but as long as you work together. So I don't trust you individually, but I trust you as a team. And I can actually say, but each time that you're going to act, you're all going to have to act together. Now, that gets tricky. And I personally, if I were appointed to act with somebody else, I would say no, thank you. because I don't have the time, I don't have the energy, and certain banks actually have problems accepting checks where there's more than 2 signatures on it, right? So if all checks need to be co-signed or tri-signed, you have to think about whether that's feasible or not. What I also want to mention is we are getting new powers of attorney laws that shouldn't change what I just said, that are going to be in effect on June 13th. So certain things will change. The current power of attorneys that we have are very, very, very complicated. These are probably going to be maybe a little bit easier in their drafting for attorneys. And the advantage is there's going to be a little bit more bite to ensure that financial institutions and other places of business are going to accept these powers of attorney, because there's a lot of pushback often when you go to the bank. When the agent shows up at the bank and says, I want to transact on behalf of the principal, banks push back because they don't like the statutory New York power of attorney form. They want their own bank form. What I suggest is if you do a power of attorney, regardless of whether it's the new one or the current one, you take that power of attorney for a dry run. You go with or you send your agent to your bank or to talk to whomever and see if they provide any pushback. If there's pushback, you still are competent. You still are able to say, no, I want you to keep a record of this power of attorney. It is valid, and I want to be sure that my agent's going to be able to transact on my behalf now and in the future.
A lot of questions about wills. Some of these I will preface by saying they describe sort of personal situations, and you guys can't, I know you can't give advice on personal situations, but there might be something you can pull out. I'll turn this one into, are there situations where I should have a trust as well as a will? And the person says, all my assets are in a brokerage account and I have designated the beneficiaries. I'll turn this into a question that I have. Is it very helpful to avoid probate on as much as possible of your estate? Because certainly one complaint we get a lot from people is that surrogates court takes forever, is a mess, and that the more of your assets don't have to go through you may be better off trying to get beneficiaries on everything so that you don't have to deal with the surrogate court process. Would you agree with that statement more or less, or?
No.
Okay.
No, I actually think Manhattan Surrogates Court, is amazing. Staten Island also. I haven't heard that. I actually find the clerks quite helpful. But I understand. But I understand. It is an additional step, right? A will is going to cost less than a trust. There are surrogates court fees depending on the value of the estate. So people are designating beneficiaries, which means that there's not going to be anything they're thinking that there's not going to be anything in their estate. But chances are there will be. Right now, right now I have an estate, the teacher's retirement account, teacher's retirement fund. So the person who died was a retired teacher, and they're holding funds for her. Somebody's going to have to open up an estate in order to claim these funds. So they're going to have to go through surrogates court. And also designating beneficiaries. Who is paying for the funeral? If you care. Some people are kind of like, I don't care what happens to my body afterwards, and that's perfectly fine. But a lot of people do. And when you designate a beneficiary, are you sure that this person is actually going to wind up paying for your final wishes? Because money that is in your estate, the first thing that happens with estate assets, what gets paid off the top are your reasonable funeral expenses. So it's difficult to really answer these questions without seeing the exact makeup of what your situation is, because my answer is going to be completely different as to whether you need a trust or not, depending on your situation. Obviously, one of the benefits of a revocable trust, so it's clearly not Medicaid planning, but the benefits of a revocable trust is that in case something, so you would be initially the trustee of your belongings, but should you not be able to handle these assets anymore, well, you have a successor trustee that's going to be able to step into your shoes and still manage whatever's in trust for your benefit. So there is an advantage to that. And yes, there is the advantage that it goes without going through probate. So it depends on how you decide to set up these puzzle pieces.
Got it. No, that's helpful in terms of sort of what kinds of questions you need to ask in determining what you need. How does, you had mentioned, sir, that there's a definition of a family member that surrogate's court has to notify. Is there a quick answer into what defines a family member for surrogate's court? Oh,
yeah. It's those that would take if you die without a last will and testament. No, I'm sorry. The people that need to be put on notice are those who would get under the laws of intestacy. So obviously, if you die without a last will and testament, those are the people who are going to get, so they're going to need to be put on notice. If you die with a last will and testament, and let's say I leave everything, and I'll go more into detail in terms of the family members. If I leave everything to Wendy, the way the law looks at it is, first, do you have a spouse? Do I have a spouse, the dead person? Do I have a spouse? Okay. If yes, that spouse needs to be put on notice. Do I have a spouse and children? If yes, my spouse and my children need to be put on notice. If I don't have a spouse and I don't have any children, that's where it trickles down. It's the same as the laws of intestacy that I mentioned earlier. Then my grandchildren need to be put on notice. If I don't have anybody, no spouse, and nobody that it can trickle down to, then it's going up. Then my parents need to be put on notice. And if I don't have any parents that survive me, then it would be my brothers and sisters of the full or half-blood, or my nieces and nephews, if any of them have predeceased me. So these are the people that need to be, and it keeps on going. I mean, it keeps on going to cousins and first cousins and all of this stuff, right? But that's the idea.
But so if I have a spouse and 2 children, those people would need to be notified, but then they wouldn't need to notify my parents because that would cut off the grouping.
That's correct.
They have to find somebody to notify.
Right, exactly. Your closest blood relative. And that's where genealogists also come into play. Because if you don't leave any breadcrumbs, or you don't know where your family members are, or if you don't want to investigate during your lifetime, whoever's going to be in charge of your estate is going to have to do that investigation and potentially hire a genealogist.
Okay, one last will question, at least for now. Discuss estate values under 30,000 regarding need for probate below that value. Is that they just don't need to go to surrogate court, or how are they handled?
No, the idea. Well, it used to be 30,000. Now it's 50,000 for a small estate. That means that if I die, leaving no real property, and less than $50,000, there is Wendy goes to surrogate's court, files a $1 filing fee because Wendy is my daughter. And I'm not married, so it's just Wendy, and she's my only daughter. And she needs to get access to my funds, and I did not designate a beneficiary, so it needs to go through this process with surrogate's court. And it's worth less than $50,000. It's a $1 filing fee. There's a DIY small estate procedure form on the web that one can complete to fill out whatever forms need to be completed. It's very easy. And of course, Wendy's going to need one of my original death certificates, because without that, the court's not going to know that I'm dead, and the court wants to make sure that I actually am.
Okay, you touched a little bit on this, but I think it's one that we get a lot of, so I'm going to ask a different version. Please speak of the lone individual without family or trusted friend. Does not mean without money. And how can they find a responsible person to take over in an emergency? Are there fiduciary responsible organizations who can be hired to manage the needs of a single person?
Well, I think in terms of assets, I mean, you can create a trust, and if you have assets, you can have a trustee that can be a financial institution to handle that part. In terms of, and Wendy, I'll let you elaborate maybe a little bit more on the healthcare side. But what I'd like people to think about is, if you're thinking about a will and where your property is going to go to, and you're thinking about individuals, can you please also think about these individuals in terms of potentially stepping into your shoes if you need help? And Wendy, I'll let you talk a little bit about.
I was just going to say that at DOROT, we frequently work with a set of geriatric care managers who are licensed and bonded, and who many times are appointed by their clients to act as, trustees and other things. They have it's a relationship that is paid. Geriatric care managers aren't volunteers like DOROT social workers, or we're not volunteers, but there's no fee for you to engage our services. Regarding healthcare proxies and powers and living wills, unless you have somebody to appoint as a healthcare proxy, we encourage people to create living wills according to the specifications that I spoke about earlier in the presentation. And there was a question in the Q&A, what if you're traveling, you're not home, and your living will isn't accessible? We encourage everybody to distribute those far and wide to your healthcare providers, and also to carry a wallet card that indicates who to contact in case of emergency, and a healthcare proxy. And we also have new living will wallet cards.
Great. A couple of questions about care, end-of-life care issues that for people who can't take care of themselves anymore. You had mentioned that Medicare doesn't cover a lot of things. Does private expensive long-term care insurance replace Medicare for a nursing home or for home care? And somebody else asked, what if you don't have long-term care disability insurance? But that's the problem. Either you have to go on Medicaid, or you got to figure out how you're paying for it yourself.
Right. I think you answered the question.
Okay.
Okay,
good.
I think you answered the question. For long-term care policies, each policy is different. The cost is different. I can't give like a very broad indication of, please read your policy, put a summary of what it means. If there's certain places that you like better than others, should you need long-term care, you should leave breadcrumbs and tell people, this is the place where I want to go. And my long-term care policy, and often the long-term care policy only kicks in after a few months. There's a waiting period. So who's going to pay for your care in the interim? Do you have funds available for that? There are a lot of there are a lot of moving pieces to that as well. So it's tough to give more information.
Okay, and then a couple of Medicaid/Medicare questions, on technical questions. For community Medicaid eligibility, when does the 30-month look-back period for transfers take effect? It was October 1st, 2020. Has that date been pushed up? I don't know if that's something you can answer.
So no, so I'm not a Medicaid attorney. So we did provide you with the information about Evelyn Frank Legal Resource Program at New York Legal Assistance Group. There is also, I'd also provided you with a link on where you can really get a lot of what I discussed in a written format, and it's hundreds of pages. So these things, I mean, this information is available, but definitely not through me.
Okay, got it.
I would not want to go into.
You've made the referral, which is to the Evelyn Frank program at NYLAG, and that's we'll make sure everybody's got that information. And this one may also be for it may also be for Evelyn Frank. Yeah, somebody just posted that. Justin did. The latest Medicare provisions for healthcare at home, i.e., having an aid to help with the basics. Is that something that they should ask Evelyn Frank as well?
What was the question?
This was, what are the latest provisions for Medicare provisions for healthcare at home? What can you get through Medicare? I know it's limited. Having an aid to help with basics is what they're putting up as the possibility. But I think your key point is it's for rehabilitation purposes, not for long-term care. So whatever
That's correct.
Yeah, and
that's correct.
Whatever you can get has to be for rehabilitation and has a limited duration.
So actually, whatever is covered by Medicare, you will know about because it's going to be in your discharge plan, right? So when they discharge you from the hospital, and the social worker talks to you and is like, well, this is what you need, and et cetera, then you have a back and forth with the social worker in terms of how does this get set up and with Medicare and what do I need to do.
But there's not something that you can't, if I'm just at home and I'm not sent to the hospital, I can't suddenly say I need a home health aid for rehabilitation and get it through Medicare.
No.
Got it. That's
no, that's good.
I thought that was the answer, but okay. Unfortunately, that is the answer. Okay. I'll throw this out there and you can answer however you, whatever you know or don't know about this. What does the landscape look like for Alzheimer care in the next decade? And how does one prepare for it without being victimized by bad actors who manipulate the system to become guardians, basically to go get control of a person's assets? And certainly there are some really bad stories about guardians, mostly not in New York, but I imagine it could happen here as well.
Yeah, right, and there was that movie, right? When we got that question, I care a lot, and I know that a lot of people have seen that about this horrible guardian. In New York, I mean, there are safeguards that are set up with our guardian, and I've read horror stories from other states. But in New York, we do have a setup to ensure that the guardian does what they need to do. Now, I do realize that a lot of people in the community who do have guardians are not happy with that. And I understand why they wouldn't be happy, because now somebody is managing their finances. What happens often is a guardian is appointed, namely when you're at a risk of eviction because you have not paid your rent for a few months, and you might get evicted, and we as a society would rather that you be able to remain at home and safe. And if rent is not being paid, even though you do have the finances to do that or need to set up some financial management, the courts get involved to make sure that you don't get evicted, and a guardian might be appointed to ensure that your rent gets paid and that you remain in your apartment. If you have people that you trust, the best way of going about it is by doing a healthcare proxy and by doing a power of attorney, making sure that you get to choose who's going to be handling these affairs if you are no longer able to handle them. But honestly, I mean, if there is a power of attorney, let's say there's a power of attorney in place, So Wendy is my agent under power of attorney. But what happens is I like to give money away. People come to my door and I just hand out money. So even if Wendy is my agent under power of attorney, and she might consider closing one bank account and then opening up another bank account, and then I find out about that bank account, and I'm still withdrawing money, and I'm still handing out the money to whoever rings my doorbell. Well, Wendy might be kind of like, well, the power of attorney is just not enough because I really need to take away Tina's rights. I need more than because Tina's sharing her rights with me. But at this point in time, Tina shouldn't be having these rights because she's making decisions that are really impoverishing her, and she's not going to have any money left to pay for anything. So there, Wendy might consider petitioning for guardianship to take away these rights, right? So that I can't distribute that money anymore. So it really is on an individual basis. But the way you ensure that people are in charge are by setting up documents ahead of time and deciding who's going to be your healthcare agent, who's going to be your agent under power of attorney, and who you trust. And by the way, under the power of attorney, there's also a section that allows you to appoint a monitor. So let's say Wendy is my agent under power of attorney, and I trust her, but I still like the idea that Brad might be able to check in maybe once a year and kind of like say, hey, Wendy, can you just open up the books and let me know what you spent, how you spend it? Does this make sense or not? That's a possibility. But that also means that I would trust Brad to actually take legal action should Brad, once the books are opened up and we find out that there's money missing, that also means that I trust Brad then to do something to make sure that Wendy stops with her sticky fingers. Sorry, Wendy.
and it's again, based on sort of experience, we definitely get the calls of people who are unhappy with their guardians. The guardian process is invasive. I mean, there's no two ways about it. So if you can avoid that by putting by having successful, more limited controls through a power of attorney, that seems like a good option. Just one quick clarification. What do you mean by with the wallet card? I think that's just something you carry in your wallet that indicates there are actually models of this card that say that I think we're attached to the previous event. So you can get a sample card that says information about your proxy. And
it's actually a proxy smushed down. So it's actually, you still need two witnesses. It's still a legally executed document. It is a legal document that medical care will honor.
Yeah, and so again, a lot of people, I think, based on some of these questions, will want to go back and revisit that event. Let's see.
You can reach out to DOROT also.
Yeah. How do any long-term healthcare policies cover Alzheimer's? The answer is yes. I mean, they will cover care, and Alzheimer's would be one reason. There are definitely a lot of issues with long-term healthcare policies, including the fact that premiums tend to go up sometimes exponentially, and you don't really have a way to, you can drop the policy, but then you no longer have the benefits. So.
And they're also limited, right? They're limited in duration or for an amount. So that's why Medicaid planning should always be on people's radars. And also what I failed to mention, if you're a veteran, and if you're listening to this and you're a veteran, definitely reach out to the VA and see what type of long-term care and other assistance they can provide to you and to your family. Veterans have, and that's a whole other area of the law, but veterans also have benefits that they should definitely look into. They're different from Medicaid and from what non-veterans are able to obtain.
Great. Well, I think we've reached the end of our time. I want to thank Wendy and Tina for all this valuable information. And again, there are lots of links, including how to contact DOROT and NYLAG for the specific services that they can offer you. Our next event is next Thursday, May 6th from 7 p.m. to 8:30 p.m. and it's on managing debt. If you are behind on the rent, have credit card payments and other bills in this time of COVID, you are not alone. The event will feature Sarah Ludwig, founder and CEO, and Rachel Villagra, staff attorney from the New Economy Project, and Ellen Davidson, staff attorney for the Legal Aid Society. Thank you everybody for joining us today, and have a good rest of your day.
Thank you so much. Goodbye.
Thank you. Take care, everybody.